Hey everyone, I'm Kate Miller. I am joined here today by Chris Miller. Hey Chris.
Hey guys.
Hi. All right, so Chris and I have a presentation for you today, very straightforward on the process of divorce in North Carolina. And we're talking about just the absolute divorce itself. So wanted to kind of get into some of the details of what the divorce action looks like. And Chris is going to walk us through the elements that you have to have in place before you can even file for divorce. And just a little bit about us before we really get into it. But Chris and I are both partners at our law firm at Miller Bowles Cushing that we started almost 10 years ago. We have a great team at Miller Bowles Cushing, and we all do exclusively family law. So we have currently 5 attorneys and 3 support staff who help us with all of our family law cases. So another note for you, at the end of our presentation today, I'm going to put up a screen that's got my email address and my phone number on it. So feel free to call me if you have any questions about any of the information that is presented here today. And I'll also give you access to the divorce forms that we have. These forms are not anything that we came up with. It's not proprietary to Miller Bowles Cushing, but we get some of this information from the Self-Serve Center that's available. It's a free resource for anybody to access at the Mecklenburg County Courthouse. So feel free to go visit that Self-Serve Center as well. So Chris, just kick us off. Tell us about these 3 big elements for divorce that you have to have in place before you can file.
Well, there's only 2 elements.
2?
2. That's all you need.
Okay, tell us.
One party has to have been a resident for North Carolina for at least 6 months prior to the time that you file for divorce.
Okay.
And then both parties have to have been separated for at least 366 days.
Okay.
What we mean by separation in that regard is living in separate residences.
Okay.
So sleeping on the couch or, things like that don't count as actual separation. And so you have to be in separate residences, but if you've met those 2 things, then you qualify to file for divorce.
Great. Okay. So the first 3 documents that you would want to use to fill out to get your divorce process started, we've got a civil summons, we have a complaint, and then we have a Service Members Civil Relief Act affidavit. That's a mouthful. So the 3 forms: civil summons, it's just a basic civil summons in North Carolina for civil actions where you put information about the case, and when you give it to the clerk of court, we'll talk about that more in a minute, but they'll assign you a case number. And that civil summons basically just gives information about yourself, about the plaintiff, name, address, county where you live, and then same thing for the defendant, the other party. So name and address, and the clerk of court fills out everything else for you on that form. The next document is the complaint itself, and that's the actual lawsuit that says, hey, we've been married for some period of time. One of us at least has lived in North Carolina for at least 6 months, and we've been separated for at least 366 days. So we want to go ahead and file for that divorce action. There's some other information that you can put into a complaint. If you want to resume the use of your maiden name, you can put that request in your complaint. And if you wanted to preserve your claims for alimony and equitable distribution, you would definitely want to put those claims in that complaint as well. And I'll put one more big red flag at the end about that too before we sign off here. But the complaint, pretty straightforward. In North Carolina, that complaint has to be verified, meaning it has to be signed in front of a notary. And I would encourage everybody just to check on the Mecklenburg County, really the NC Court's website, to check and see if any of the COVID emergency directives have changed that, because for a period of time, we did not have to have those signed with a notary. They just had to be, what was the word they were using for it, Chris? It wasn't verified, but it was like an attestation, affirmed. There you go. And then our last document, the Service Members Civil Relief Act affidavit, is an affidavit that you would file stating that the other party is not serving on active military duty, such that they would not really be aware that you had filed a lawsuit against them. So those are the 3 big forms that we really need to get started for the divorce process. And what do they do after they fill out those forms, Chris?
You take them down to the Mecklenburg County Courthouse and you file them with the clerk of court. And
Okay.
Clerk of court's going to charge you $225 as a court filing fee to file for divorce. Mm-hmm. And if you want to resume the use of your maiden name, they're going to charge you another $10.
Yep. Easy peasy. So The clerk's office is on the third floor of the courthouse. Easy to find. Everybody knows where it is. So if you make it into the courthouse at 832 East 4th Street, anybody in there can point you in the direction of the clerk's office. So after you get all that stuff filed, the clerk is going to keep original copies and they'll give you back file stamped copies. And that's the next step, is to take those file stamped copies of your summons, your complaint, and the Service Members Relief Act affidavit, and serve the other party. So we've got different methods of service in North Carolina. You can serve by sheriff, you can serve by FedEx or UPS, some sort of registered delivery service where the other party would have to actually sign for it. Or you could send it to the other party with an acceptance of service, which is just a document that they would sign saying that they had received the lawsuit, and have that filed with the clerk of court. So sheriff, I think it costs $15 to get the sheriff to serve your lawsuit for you. I think that's accurate.
$35.
Okay. FedEx, UPS is going to run you, right around, I don't know, $8 to $10. The acceptance of service doesn't cost anything, but you do have to take it back to the clerk's office to file that. So after the papers are in the other party's hands, they have been served, you have to wait at least 30 days, sometimes 33 days. So we just say 33 just to be safe, but wait 33 days after they've got those papers in hand to file your next set of documents with the court. So that's basically how long they have to do something before you can take your next step. So what's the next step after they're served, Chris?
Well, if they file an answer to your complaint, then you can file these documents as soon as that answer is filed. But assuming they don't file an answer, then you're correct. You have to wait at least 30 days or 33 days, depending on how you served them originally. But the next thing you're going to do is ask the court to enter your judgment of divorce. And you do that by filing a motion for summary judgment and an accompanying notice of hearing. And there's a $20 court filing fee to file that notice of hearing. And what that's going to do is the court's going to give you a date, and it's always a Monday. And you don't have to go to court, and your soon-to-be ex doesn't have to go to court, and the attorneys don't go to court. But at some point of the week of that Monday, there is a judge who is assigned to handle all of the divorces. So he or she has a giant stack of paperwork, and they're going to go through and make sure you filed all your documents correctly, make sure you have that requisite time period of separation. And if so, they're going to enter your judgment of divorce. Yeah. So what we recommend doing is when you file the motion for summary judgment and that notice of hearing, you go ahead and give the clerk your proposed judgment of divorce and a certificate of divorce, because that is the two documents that the judge is actually going to sign. Okay. So if you don't have those in the file, the judge may not grant the divorce, even if you've met all the requirements to do so.
Right. So after you have, after you've filed the motion for summary judgment and the notice of hearing, what do you do with those documents? You
have to serve those on the other party.
Okay.
You don't have to serve them in the same manner that you started the lawsuit, because there's already an active lawsuit. So all you need to do is mail them a copy. The rule has been changed recently that you can now email them a copy, but either way, you need to get it to them by mail or email.
Okay. All right. Good deal. So if all your paperwork has been properly filed and the judge grants that judgment of divorce, he or she will just sign that judgment of absolute divorce. And we also encourage folks to include a self-addressed stamped envelope with that last set of documents that you take to the clerk's office, because that helps to get it back to you quicker. Otherwise, my understanding currently is that there is a basket of divorce judgments that just gets left at the clerk's office that you have to actually go and sift through and see if your judgment got granted. So put in a self-addressed stamped envelope in there, and they can get it back to you quicker. So once you get your judgment back that says you're divorced, you have to serve it on opposing party. It's kind of the recurring theme: serve it, serve it, serve it. So file a copy or serve a copy on opposing party. Again, the mail requirement is just regular mail. You don't have to do that certified mail or sheriff. And then file a certificate of service at the court to show that you have actually served the opposing party with the judgment of divorce. And I would put just kind of one last huge note again: if you want to have a potential claim for alimony or property distribution, equitable distribution in North Carolina, you have to file those claims before that judgment of divorce gets signed by the judge. Otherwise, you are forever barred from doing that. So please don't forget that. If you have any questions about whether you should file for equitable distribution or whether you have a potential claim for alimony, call an attorney. Don't rely on, brother or neighbor, or whoever, to give you advice about that. So call an attorney and get some good advice there. So any questions for anybody? I am going to get ready to put up my my screen with my information here, my email address, my phone number, and you can call me, email me anytime. I will send anybody who calls or emails me, I'll send you a link to the folder where we save all of these documents. So give me a call at 980-321-5572 or email me, kate@mbc-law.com. That's it. That's our divorce presentation. Thanks for joining me, Chris. I appreciate your insight today.
Take care, guys. Bye.
Bye.